Thank you very much for that introduction. My presentation is going to cover a lot of ground quite quickly, and I'm glad with Professor Horgan's initial comment that really gives all of us dispensation to change our minds as we go along during the day, and I think that applies to all of us, not just him. But I think that one of the things that I wanted to focus on is around some of the inherent ambiguities in CVE policy. For some 20 years, I was involved working in central agencies in New South Wales and in Victoria, and involved in recruiting dozens of people. And one of the essential criteria for people being successful in the recruitment was their ability to deal with ambiguity. And I think the same thing applies to anybody working in public policy in the CVE space, because of the complexities and many of the things we just heard this morning reveals quite clearly what those ambiguities are and the tensions that exist between competing public policy. The other thing, and we've heard some of this morning from Professor Horgan and others, is that this is an area of policy in which academic research, government policy development, the development of intervention programs have all developed side by side. So things keep evolving and changing, and people learning from what they're implementing, and new theories are evolving. And there is these different tracks that are running together. And previous assumptions proved to be untrue, become untrue, and various things which were regarded as, fundamentals are changed. So this is a constantly evolving area of public policy. The other thing that I just wanted to touch on is that the importance of focusing on the overall strategic intent of what we're doing. That frequently when one focuses in the detail of it, there's often an assumption that we know what we're doing, but sometimes may lose sight of why we're doing it. Now, the origin of the ambiguity goes right back to the origins of current trends in CVE policy, and one thinks of particularly around 2005, and all sorts of things happened around the world. And for governments, CVE policy represents an opportunity to focus on soft power as opposed to hard power. And I think it's a comment that Peter Newman made in one of his commentaries on CVE policy, that it was a theme that encompasses a potentially unlimited range of activities. And over the years, under the umbrella of preventing or countering violent extremism, why have such an enormous array of possible interventions, from promoting sporting events to detailed works in corrections and with police, and the whole range of activities in between. Now, within Australia, the origins of countering violent extremism policy likewise goes back to 2005, reaction to the London bombings, but also to Operation Pendennis, which led to arrests in Melbourne and Sydney. So there were a lot of political maneuverings at that time. And I think it's useful to reflect on the fact that as we stand here now, we assume that governments are going to be involved in policy and interventions on countering and preventing violent extremism. But back then, back in 2005-06, there were different views between state governments and the federal government in Australia. The then federal government was not sympathetic to the idea around policy around countering violent extremism, was in fact focused more on strengthening laws around control orders, preventative detention, stop, question, search powers, as opposed to policy that focused on other elements. So the Victorian government, for instance, put out a policy that it was important, the terrorism policy, to actually shift to working on building trust, engaging with multicultural communities in partnership as a wider strategy to counter terrorism. And also initiated some of the first research work funded by government at that time. And I think one of the things which one still sees sometimes focusing people's minds in this regard is that back then there were different views as to whether countering violent extremism policy was in fact soft as opposed to some of the harder law and order type interventions. And that theme still sometimes runs through some of the work, some of the ideas and influences some of the debates going on. The other thing, of course, we've heard a lot about the UK Prevent strategy, and I think it's important to recognize it was very important in the development of policy in Australia, but it's was not copied. And I think that some of the things that happened, as I mentioned at the beginning, is that every country in the world has different approaches, they have different communities and different understandings, and therefore develop things differently. And there were many reasons why the UK policy has been developed in its way. And a useful book on social cohesion and counterterrorism, A Policy Contradiction, from 2011, I think really goes through this in enormous detail. And it's an important piece of work in this space about how the broad approach to CVEs actually created and had embedded in it an ambiguity which we're still dealing with. There's also a whole lot of other issues in the UK which go before the actual development of counterterrorism policy in that space. But one of the things I just want to touch on very briefly here is that one of the first pieces of work done sponsored by government on countering violent extremism policy was to look at this issue around the relationship between multiculturalism and extremism. And it was raised because at that time in Europe, in some parts of Europe, there was the view that multiculturalism was in fact one of the things that helped cause some of the disengagement from society. And work that was initiated, sponsored by the Victorian government, carried out by the Global Terrorism Research Centre, indicated that in Australia, more broadly, across what was called, mainstream communities, that this was not the view at all, that few participants drew links between multicultural and security threats in Australia. And it's a very different understanding of multiculturalism in Australia from other parts of the world. And I think there was that clear view that Australian identity, in a majority view, that the Australian identity is diverse and dynamic, and it's not defined by a particular heritage. The next thing to think about is counterterrorism adopted into it the concepts of violent extremism. And I think that this was itself a contested area as to whether CVE was actually part of counterterrorism policy. And we've heard the different states and different parts of Australia actually have different views of it. It was incorporated into counterterrorism policy in Australia, and in its 10-year annual report, come out in 2012, the National Counterterrorism Committee stated and outlined this shift, as it pointed out in the annual report, which is available online. While traditional military law enforcement intelligent approaches to counterterrorism continue to remain paramount, addressing long-term causes is also vitally important. A central component of this is involved funding and coordinating CVE projects across Australia, with the aim of reducing homegrown terrorist attacks by strengthening Australia's resilience to radicalisation and assisting individuals to disengage from violent extremist influences and beliefs. These activities address factors that make people vulnerable to extremist influences and empower communities to intervene before a law enforcement response is needed. And some of the key things, and as mentioned here, working rehabilitation of convicted terrorists and prisoners, community strengthening, training and education for government officials and communities, and CVE research. So that set out then what had been worked on for a number of years previously, the basic parameters of CVE, which is this broad spectrum And today, from the CVE approach, as publicly stated, still contains these 4 components around building strength, diversity, and social participation, work with vulnerable communities, and right down to the diversion and de-radicalization. So I think that when one looks at the whole spectrum of interventions within Australia, that, and this is from the expert panel on terrorism and violent extremism report from 2017 in Victoria. Now, there's a lot of detail up there, a lot of color, right, is more important sometimes the details, but the green column depicts prevention programs that have a community-wide focus. CV programs are designed to build protective factors in communities to address the risk of violent extremism. The orange column signals a shift to interventions directed towards individuals showing early signs of radicalizations toward violent extremism. Generally, these are lower level emergent risks that can often be managed by addressing the underlying drivers of concerning behavior, such as unemployment, drug and alcohol issues, and social isolation. And the red section on the far right is reserved for the management of risks of immediate concern. These interventions are geared towards individuals who are radicalized towards violent extremism, having passed the points of prevention and early intervention strategies. So one has set out there this whole broad spectrum, which really covers everything from these early things which involves multicultural agencies and others, all the way through to corrections and police and intelligence as well. Now, one of the things that, and has been mentioned before, and Paul Thompson mentioned, there was a high level of criticism of the first wave of CV programs. And I think that one of the things that was identified in the United Kingdom was, as it pointed out in the 2013 article, the desire for governments to work with affected communities is fairly uncontroversial, but it leaves a fundamental question unanswered. Is prevent about community empowerment to solve the problem of extremism, or about overt surveillance and gathering of intelligence, or both? So this outlines the issue, which was right from the beginning, a particular set of ambiguity in what the work we're doing in this space is. And as one well knows, the first wave of CVE had a whole lot of criticism about the mixing of community cohesion and counterterrorism agendas. It was said that rather than a case for community cohesion work, can it be made to work without reference to the CV objectives? And people will be aware, very much in this room, a lot of work was done, a lot of commentary done in the UK, but also in other places, is that this term CVE had become toxic because it was associated with these hard end elements, but was also including these social cohesion type ones. And many people here will be familiar with this highly influential document, Spooked, by Aran Kundnani in 2009. Now, I put this up here because it actually was influential in Australia as well. It's the point that I want to make here is that even though CVE policy in Australia followed a different course and did not have many of the elements of UK policy, the criticism of UK policy was often adopted into criticism of Australian policy. And I think that this actually has meant that the many of the issues that were raised in Spooked, and we've heard this before, and many of you would know about this, around the fact that it was seemed to be focused in particular on Muslim community, and as Spooked comments constructed the Muslim population as a suspect community, was something that also influenced the criticisms of work in Australia as well. And indeed, one of the things that I have heard in discussions with community leaders in Australia is that examples from countering violent extremism policy in the UK have been cited to me as as if they happened in Australia. And I think that is actually one of the problems in having a debate about these issues, as because of this in the globalized world, some of the articles and discussions that were raised in other parts of the world have also entered the discourse here. That doesn't mean to say that there weren't issues in Australia too, but I think that it's actually important to understand that there are this connection. You know, the prevent strategy in the UK did have an influence on policy development in Australia, but the criticism of it also had influence on the way in which opposition to policies developed in Australia worked as well. But the other thing is that the criticism, which goes back to that initial point that I made, which arose in 2005, you've also had media commentary on CVE policy that it's regarded as, in fact, too soft. Here's an article from the Daily Telegraph in Sydney from 2019, and the article says around secretive program fails test, and really it was criticizing government policy for, as it said, investing more than $53 million to counter violent extremism, when they're saying that actually hadn't worked. And it's what happens is there's a single instance is seen to be, in fact, a general principle. Certainly, since then, we've had the second wave, which has learnt, about many of the issues around community engagement, stronger focus on individual level interventions, and more focused on CV-related issues such as hate crimes. The other thing that I think is important is obviously the distinction between CV-specific and CV-relevant issues. And as Peter Romaniuk identified, that there's specific things which are focused on, preventing or suppressing violent extremism with direct fashion, and CV-relevant frame more generally intended to reduce vulnerability. And I think that that's probably a useful distinction that we have. So these debates in Australia have continued, but also clearly, and people here would know that in the UK, a lot of discussion around and lots of reviews, including reviews last year. But even with those changes, for instance, just last year, a commentary on rehabilitating revenge strategy called on the abolition of prevent because of the immense levels of harm it inflicted and its institutionalization of Islamophobia. So the issues around who should be responsible for this actually is part of this ambiguity. We've heard initially central agencies were involved, Cabinet Office, Premier and Cabinet, Prime Minister and Cabinet. Here in Australia, some of that's moved to Justice Departments. In New South Wales, as we've heard before, CVE policy is still focused very much on within and separated from CT policy. So this ambiguity has actually meant there's often different views about how this should be done. So this whole spectrum that we've mentioned actually raises the question, which is how broad should this spectrum be? Should it actually just be one side of things? Should it just, for instance, focus on the sort of pointy end of CVE, or should it in fact still continue to focus on the social cohesion elements? And in fact, what I'm positing is, in fact, there's no necessarily agreed view about this in Australia at the moment. So the last thing that I just want to mention, of course, is that with the rise of the anti-democratic agenda from right-wing extremism, has actually raised the importance, I think, of this focus on social cohesion as being part of CV overall. So this ambiguity, I think, needs to be embraced. One can't neatly say it is just one side, the red columns or the green columns, but it's in fact all of it. And there's a strong argument that now we need the full spectrum more than ever. We need to accept that there's ambiguity in preventing and countering violent extremism, certainly learning from the past and adapting to current challenges, cannot focus just on hard interventions, but need to continue a focus on building protective factors, including democratic resilience. The growing growth of an anti-democratic, racially exclusive movements and extreme right-wing means challenging these extremists are more important than ever. But clearly, across Australia and indeed other parts of the world, who is best to carry that out by government and which agencies should take the lead and how whole of government approaches are implemented are in fact still very much current questions. So thank you very much.
Thank you, Mark. There will be questions at the end of the entire session. Hopefully there'll be a few questions from our from my team. I know policy is a particularly pointed issue. We have another presenter now who had seen the forecast and decided that she would do hers remotely. So Joana Wong is our next presenter. She is a principal solicitor with New South Wales Department of Justice and Communities, and she is presenting on the role of rehabilitation under the Terrorism High Risk Offender Act 2017. We'll get this one queued up.
My name is Joana Wong. Years, and I specialise in preventative justice laws. I was involved in the implementation of the New South Wales counter-terrorism legislation, known as the Terrorism High Risk Offenders Act, and draws on my research detailing the first systemic review of cases under the Terrorism High Risk Offenders Act, and examines the role of rehabilitation under this novel and challenging piece of New South Wales counter-terrorism-related law. In this paper, I suggest 3 areas of reform in order to better achieve rehabilitation under the legislation. On 15 December 2014, Man Monis, he was known to police at the time, having been released on bail for the charge of being an accessory to the murder of his former wife. But he had no terrorism links known to law enforcement authorities. Tragically, the event resulted in the death of 2 hostages. A coronial inquest was held, and Menmonis was found to have committed a terrorist act.
As you can see, Joanna's was pre-recorded. We're just having a little bit of technical difficulty there.
The TRO Act provides for post-sentence supervision and detention of prisoners who pose an unacceptable risk of committing a serious terrorism offence. It comes within a novel area of law called preventative justice, which falls outside the criminal jurisdiction. It is protective in nature, in that its primary purpose is to protect the community from a predicted risk of future harm, much like AVOs and bail laws. What sets this law apart from other preventative justice legislation is that the TRO Act targets New South Wales offenders who have not been convicted of terrorism offences, but who present with residual risks of terrorism at the end of their sentence of imprisonment. This lack of nexus between an offender's original offence and the offender's future risk of terrorism sets the Act apart from all other preventative justice laws in Australia and around the world. The TRO Act is considered controversial by legal practitioners and legal scholars because it departs from acceptable legal standards of criminal law. Post-sentence detention and supervision schemes have become increasingly popular as a mechanism to combat crime in Australia and globally. These schemes exist in nearly every state and territory in Australia with respect to convicted sex offenders. Interestingly, New South Wales and South Australia are the only jurisdictions in Australia that target terrorism-related offenders who have no prior conviction history of terrorism offences. Despite the popularity of these schemes, particularly with respect to sex and violent offenders, there is limited research available on the operation and effectiveness of these laws in protecting the community from the future harm it is intended to prevent. Turning to the THROW Act, there are two key objects of the Act. The primary object of the Act is to ensure the safety and protection of the community, and the secondary object is to encourage offenders to undertake rehabilitation. While community safety is the paramount consideration, the Supreme Court must also have regard to the rehabilitation of offenders. To date, there have been 25 cases finally determined by the Supreme Court and one case in the Court of Appeal under the THROW Act, with approximately 50% of the cases resulting in orders being made. This presentation will focus on those cases where the court has made final orders for supervision or detention. A structured thematic analysis of the cases reveals that the New South Wales Supreme Court has demonstrated minimal regard to rehabilitation of offenders when making orders, resulting in orders that focused mainly on managing an offender's behaviour rather than encouraging rehabilitation. Whilst this achieves public safety for the duration of an order, it has limited benefit in the long term because final orders have a maximum term of 3 years. It's argued that by shifting the court's emphasis to rehabilitation, the primary object of public safety could be better achieved. This research reveals 3 areas of reform where it is suggested rehabilitation could play a bigger role under the Act. Firstly, placing greater emphasis on rehabilitation as a mandatory factor, which the court must have regard to when determining whether to make orders. Secondly, placing greater emphasis on rehabilitation in expert reports that are provided to the court. And thirdly, shifting the legislative focus to disengagement. In determining whether to make an order, the court must have regard to Section 3 of the Act. They include an offender's criminal history and court sentencing remarks, an offender's belief or their an offender's behaviour on previous parole orders and the likelihood of their compliance with supervision orders under the THROW Act, expert report, results of risk assessments like the VERA 2R and the TRAP 18. And out of the 13 mandatory factors, it's interesting to note that only one factor refers we can see that across the cases where continuing detention orders and extended supervision orders were made by the court, rehabilitation in the court's judgments. Rehabilitation represents only 11% of the THROW cases. The opinions of court-appointed experts, risk assessments, and terrorism experts are also matters which the court must consider. But because of the variability of their content, that is, the expert reports refer to many different issues, references to expert opinion were removed from this chart to allow for greater focus on the specific issues that are outlined in the mandatory factors. Despite rehabilitation being the secondary object of the THROW Act, it can be observed that the Supreme Court places a greater emphasis on an offender's beliefs, their criminal history, and previous court sentencing remarks than they do on rehabilitation. Remarkably, the beliefs and motivations of an offender make up more than 50% of THROW judgments. This is interesting because we know that a person's belief alone is not determinative of the risk they pose of committing a terrorist act. It would be useful to see if different types of beliefs have any bearing on the outcome of orders under the Throw Act. When the opinion of experts is introduced as a further criteria into the data, namely the opinions of risk assessment authors, court-appointed experts, and terrorism experts, the results reveal that expert opinions feature heavily within throw judgments, that is 32%, but still less than that of an offender's belief, which is 36%. Rehabilitation still trails far behind, making up only 7% of throw judgments. From the results of this thematic analysis of the cases, we can see that the court falls well short of what we would expect when it comes to rehabilitation of offenders. This is not surprising when rehabilitation makes up only one of the 13 mandatory factors that the court must consider. This is likely to have a significant influence on the court's decision-making. By revising the mandatory factors to place more focus on rehabilitation, we are likely to see outcomes that will better achieve community protection and public safety in the long term. From the data shown earlier, it is observed that the court relies heavily on expert opinion in forming a view about an offender's risk and the types of orders that should be imposed. The contents of expert reports therefore have a significant bearing on courts' decisions when it comes to making orders, especially the types of conditions that are imposed on extended supervision orders. An analysis of cases determined by the court reveals that experts in these matters rarely refer to rehabilitation or treatment options with respect to terrorism risk factors. They tend to focus on risks to public safety, namely an offender's risk factors and the likelihood of the risk eventuating. There are several reasons why this might occur. Firstly, the Act does not require experts to consider rehabilitation. Under Section 25, subsection 3, the court must have regard to reports received from court-appointed experts with respect to their examination of offenders and the level of the offender's participation in any such examination. The Act makes no mention of rehabilitation options as one of the issues which the expert reports should address. Similarly, the court must have regard to other assessments by psychiatrists and psychologists as to the likelihood of the offender committing a serious terrorism offence, as well as the willingness of the offender to participate in an assessment and the offender's level of participation in the assessment. Again, there is no mention of rehabilitation options as an issue which the report must address. Recommendations as to treatment and rehabilitation options will vary because each offender presents with a different set of risks. Offenders' risk profiles are constituted differently in terms of beliefs, motivations, intentions, and capacity to carry out harm. They cannot be effectively treated as a homogeneous group. What is appropriate for one offender will therefore be different for another. The recommendations as to treatment options will similarly vary. In some cases, the recommendation may be for an offender to participate in an existing service, but in other cases, due to the unique risk profile of the offender, there may not be services in place that would assist with the offender's rehabilitation. This makes it difficult for experts to proffer an opinion as to suitable rehabilitation and treatment needs. Thirdly, participation in treatment is voluntary. For rehabilitation to be effective, an offender must be a willing participant, and this involves an acceptance by the offender that they pose an unacceptable risk of committing a serious terrorism offence, even though the offender has no prior conviction of such an offence. Participation in most treatment options, however, is voluntary and difficult to enforce. This can pose a barrier to treatment being recommended, especially where the treatment option is considered to be critical to the risk mitigation strategy for an offender. Fourthly, treatment options may be too expensive or too difficult to implement and supervise. The cost of treatment will also vary, and this can often pose an impediment to a supervising authority who is tasked with funding and implementing treatment. Despite the challenges with rehabilitation and treatment options, it is argued that experts should have greater regard to suitable and available rehabilitation and treatment options for offenders. Given the court's heavy reliance on expert opinion in these matters, the opinions of experts as to rehabilitation options is likely to significantly influence the orders made by the court. This is especially the case for extended supervision orders, where the court has a wide discretion as to the types of conditions imposed on orders. An extended supervision order that has rehabilitation as its central focus is likely to achieve public safety long after an order expires, compared to orders that focus on public safety alone. A third area of suggested reform is for the court to focus on disengagement rather than rehabilitation. The concept of rehabilitation is contentious because it necessitates changing an offender's belief system. It suggests the need for de-radicalization, that is, the need to change an offender's core belief. In New South Wales and the Commonwealth, countering violent extremism is in the form of disengagement and not de-radicalization. In other words, the treatment focus is on managing an offender's behavior, such as refraining from violence and moving away from negative influences, rather than changing their core belief. Further, it's difficult for the court to grapple with the concept of rehabilitation. To have regard to rehabilitation, the court must first be satisfied that an offender poses an unacceptable risk of committing a serious terrorism offence. Secondly, it must then identify the risk factors that require rehabilitation, and then only would the court determine the forms of treatment that will result in the offender being rehabilitated. This is not an easy exercise for the court when offenders who are eligible for orders under this Act have no prior conviction for terrorism offending. The ultimate question which the court must determine is one of unacceptable risk, not of rehabilitation. The Act provides no guidance to the court as to how rehabilitation should be factored into its decision-making. Arguably, the court is not well placed to determine rehabilitation, nor is it equipped or trained to form a view as to rehabilitation either. A better alternative is for the court to focus on disengagement rather than rehabilitation, which it could do so by referring to expert opinion on the treatment options available for disengagement. In summary, it is recommended that rehabilitation could be better achieved by revising the mandatory factors in Section 25, subsection 3 of the Throw Act to place more focus on rehabilitation. Secondly, expert opinions should be addressing rehabilitation options for offenders. And thirdly, focusing on disengagement rather than de-radicalization. Thank you for listening to this presentation, and I hope you found it helpful and interesting.
Thank Joana. She's obviously not with us, and some really interesting for anyone who knows a lot about these legislations, how the different wording can vary slightly in legislation and how big an impact it has operationally. So hopefully there'll be lots of questions. Mark, if you would like to come up and join us, and if anyone has questions for Mark, please put your hand up. I'll start with one if no one in the audience has one just yet. Mark, you've spoken a lot about the difference between the ambiguity in terms of looking at social cohesion versus the CVE pointy end, as you called it. Have you looked at all at the impact of the different uses of the term risk? Joana obviously spoke about unacceptable risk. We have legislation in Victoria around justice amendment legislation for our state-based offenders, an assumption against parole, which just says risk without defining what that is. Has there been any work or been put into looking at the different definitions of risk?
Well, certainly, I think the whole risk assessment set of issues are fundamental to this. But in terms of the pieces of the legislation which you've been talking about, of course, exists in a way of codifying what that risk is and what's acceptable and what's not, and the factors that should be taken into account. So I think if you're talking about the pointy end of elements, then I think that while I've not looked at those particular pieces of legislation in recent times, that they are fundamentally important. But I think that one of the broader issues we're talking about managing risk is when we're considering CVE policy or CVE policy more broadly, was the assumption maybe by some government agencies that the focus on social cohesion elements was in fact risky policy because of the issues which I've raised and which most people in this room would be fully aware of, because it actually seemed to be focused on particular communities, and therefore there was often an attempt to or movements to actually walk back from some of those more sort of social cohesion type elements because of that initial view of what happened with the first wave, that in fact they securitized community relationships rather than allowing them to become real partnerships. So I think that that's part of the kind of the risk management that took place. But I think that one of the things is in as we know, in CVE policy or CVE intervention, there is no risk-free intervention. Every intervention that anyone's going to make at any level or whatever point in the spectrum actually has some risk attached to it. And we can't actually remove what that risk is. We just need to understand what it is and what's acceptable and what's not. So I suppose that's some of the issues that I'm raising, is that as I say at the beginning, if one wants something that's completely neat and in a self-contained box, then you actually have to reduce the types of activities you're going to engage in. And so I think that's it does take it is risky to do some of these things, but it's important to do them nonetheless.
Thanks, Joanna, for your presentation. I just had a question in relation to conditions. So you mentioned that the Throw Act doesn't sort of stipulate what conditions can be used. And I know in the state-based context, in Victoria, legislation does detail core mandatory conditions. And I'm wondering if there's an appetite for mandatory or core conditions to be added to the legislation.
Thanks for the question. Can you hear me? I'm not sure if my laptop's working. Oh, great. In the Throw Act in New South Wales, there are a set of conditions which are not core but are preferable. So that's under section 29(2)A, I believe. And it sets the tone for the types of conditions that the court is likely to make. As to whether mandatory conditions, whether there's an appetite for mandatory conditions, I'm not really able to answer that. I think there are stakeholders who would like those conditions to be imposed, but the risk with mandatory conditions is that it may impose conditions on offenders who shouldn't have those conditions imposed. As I was saying in my presentation, the risk profiles of offenders vary, and it's a very dynamic area. And to have a set of conditions that are the same across one offender to the next, you run the risk of orders being implemented in the same way when it should not be. But in saying that, I can see the benefit of having mandatory conditions if the conditions are about powers. Presumably, if stakeholders or law enforcement agencies were to implement those type of powers, to know that they have them, they can exercise them with discretion, and that would be a matter for those agencies to do so. But yes, unfortunately, I can't answer that question on behalf of the government.
Well, thank you to both Joanna and to Mark for their presentations today. And if anyone has any other questions for Mark, he is here, and Joanna, I'm sure we'll take them on email and on notice. So thanks, everyone.